or actions you take in your lifetime to plan for your estate.
How many of you here knew that we offer estate planning services? That's good. Yeah, at a cost.
I'm so sorry, no, sir.
Right. We not only offer it through the credit union, but also in our group of companies as well. You could take certain actions through capital insurance brokers. Part of estate planning is starting to acquire life insurance policies. You need an insurance agent for that. Capital insurance brokers will be able to assist. It includes investing, premier plans. It includes opening that joint account. That's a saving product that Harriet mentioned. It includes creating a will, and it includes creating a power of attorney, which our legal department offers their service.
So when Shannon mentioned insurances, life insurance is beneficial to your estate and your beneficiaries, of course, but it's also beneficial to clearing debt that you may have. Let's say you have a mortgage. With the credit union, a part of the collateral is requiring life insurances, and that is in order to ensure that on the death of either of you, any of you, that your life insurance will be able to cover the loan balances on that loan. And that's important for your beneficiaries, and we hope that you take it as something important to you and ensure that it's something that you be mindful of when you make your payments monthly towards life insurance.
Right, so you want to keep it current because you want that if, God forbid, anything had to happen to you suddenly, that loan is cleared off and your beneficiaries are not left to worry about, oh gosh, who is going to cover the mortgage, who's going to cover this loan, who's going to cover certain things, because I have put certain things in place with that life insurance policy.
And yes, we spoke a whole lot about these decisions. I hope that we would have resonated with each and every one of you. There are many things to be considered, and the most important of them all is assessing your circumstances, considering what we would have discussed, and determining how it fits into your life.
Yes, identifying those assets, identifying those liabilities, making sure that, say you have a mortgage, that your life insurance that is covering your mortgage with us is paid up to date. Because as we mentioned, life is so indifferent. You don't want something to suddenly happen to you, and then you wonder, what if I had put things in place?
Yeah, and taking certain steps in your lifetime is important to do so, and taking steps in your lifetime when you are mentally able to do so as well. Taking steps in your lifetime might look like opening joint accounts sometimes with a person that you care about. It could include transferring property in your lifetime to that individual. It could also include preparing a will or preparing a power of attorney depending on the circumstance. So it's important that we be mindful of these different steps that we have or the choices that we have available to us, and ensure that you consider them in your estate plan.
Thank you so much.
Thank you for
You've been such a great audience. Any questions?
Hi. Could you go to the mic?
Hi.
In relation to the preparation of the will and the afterlife expense, is it possible, and I'm assuming it is, that you could put into the will that I am leaving a set of money to the executor in order for her or him to do the duties that they need to do?
You can put that in the will. However, because it will be tied up in the estate process, you cannot access those funds until you clear off certain debts and liabilities. So that would be the first in priority. That's not a concern. But in order to get the estate application going, initial expenses will still be required. That really cannot be touched from the estate funds.
It may call for some extensive estate planning. If it is that you assume that it will cost $5,000 to get the process started, you can put it in an account with the executor.
Yes.
Yeah.
And that is one of the joint accounts that we mentioned that you can create.
Thank you.
You had mentioned that there are some aspects of doing the probate or letters of administration, I presume, that an attorney should be used besides the preparation of the will. What else is there for testamentary?
Right. So the preparing a will is only really the first step. After you have died, it is just not automatic that the gifts will go to those beneficiaries. The will has to be verified, and that is verified through a court process, right? So the attorney will facilitate making that application to the court. Like, hi, this person has died, this is their death certificate, they left a will, please verify that this will, they had no other wills, that this will is their true will, their last will and testament. And then they will be able to transfer that property to the beneficiaries. It isn't automatic just because you prepare the will. It needs to go through what we call a verification process, which is administering the estate. So you're going to make sure that those debts are cleared off before the beneficiaries get their gifts. Good evening.
I have a couple of questions for you. One, making a will and your witnesses die before you, that's one. And two, if the witnesses refuse to sign the will. The third question is, what is the cheapest way of transferring property even after you die, rather than going through these long drawn-out processes? I've been hearing about putting your property in trusts, that it can pass so much easier to your beneficiaries without going through this lot of expenses. Is that true?
All right.
Well,
You asked a series of questions there, so let's start one by one. So the first one you would have asked.
if the witness died after you've made the will.
Before you die.
Well, remember, the witnesses are independent from your will. If they happen to pass away after they signed your will, it still makes your will valid.
There is a process of having persons verify the signatures of the witnesses to your will.
Right. So that's why it's two. Because they will be able, the other one will be able to say, yes, me and this person that's deceased was alive and saw you witness the will.
But if those two persons predecease you,
There is the same thing applies where someone who knows those individuals can identify the signatures of being the parties who witnessed your will
Right, so their signatures will need to be verified.
and secondly,
by someone else.
if either of them refuse to sign off on a will,
Well,
Remember, it could be anyone that's independent from the will. So if those two didn't want to do it, if
By
another
somebody
two.
else?
no, what I mean is they have witnessed your will, but now you become deceased, and they're refusing to sign off as witnesses on the
Oh,
will.
you mean to verify that they witnessed your signature?
Yes.
That happens, but I believe that you would have to tell the court the circumstances. Listen, I've made all attempts to get this witness to verify that they witnessed my will. They're being difficult, and the court would then guide what steps they're going to take.
And there are some steps that some attorneys do take, and on creating the will, some persons actually create that affidavit to prove the witnessing of the will at that particular time, and it kind of eliminates that step of it being a
Looking for a
situation where
witness,
they
the
aren't going to
witness.
sign off.
Yeah.
And thirdly, the cost process of leaving your things in trust, that makes it a lot cheaper.
Well, we can't really speak to the trust process because we don't really manage trust in our role. But with respect to both having the trust process as well as having the will and administer through that process, both comes with a cost. When it comes to the transfers, there is the cost of the transfer of the property, and there is the cost of the applications before it gets to the transfer. When it comes to the trust situations, there's the payment of the trustee for managing the trust itself. Yes, the trust can provide for opportunity for ownership to those particular persons that you designate, but in either case, there is a cost. You might need to speak to a trust management company to assess what costs will be involved in that process.
I believe it may be based on the value of your estate.
Hi, good night. Quick one. You are legally divorced. You have one child from the marriage. However, one of the spouses have remarried and now have a child. The property that you owned when you were married still belongs to yourself and your ex. How do you protect that child who, in my estimation, the property belongs to them because it came from their parents' marriage? How do you protect that child?
Well, we would have hoped that in the divorce proceedings, we would have some property settlement arrangement.
And they didn't. How would you deal with?
That is part of being legally divorced, that you settle all assets for the marriage. So I would say if you are still battling about property settlement, it may mean that you might be legally divorced on paper, but still have some things to tidy up. So really, we used to make sure that property settlement was done before you get that official divorce, so you could avoid cases like this, but now it's not a requirement. So it's really best, though, that you start to put those things in place.
Okay.
Because you might be divorced, but still dealing with property settlement.
Yeah, and there's no way to avoid that situation you would
Right,
mention.
because the spouse is entitled, either legally or beneficially.
Okay.
Any other questions? Oh. Thank you.
I keep hearing the question of capacity through the entire presentation. And is that something that has a litmus test? Is it measured? Do we have to be certified as being having the capacity to make a will, or would it be assumed, as you use the word, I'm young, I look healthy, that I have the capacity to make a will?
There are medical tests that doctors could administer, and they will test your mental capacity. So yes, the answer is yes, there are tests. So not necessarily that you're young and vibrant, but if you believe that something is impacting your mental capacity, there is a test that doctors could administer. There are questions that they can ask to test your memory and your mind. Hi, yes, I thought I saw a hand in the back.
Yeah.
Oh, sorry.
Hi. What if an individual has a number of children and has a will in place, but decides to get married? What happens to that current will?
Well, right, as we mentioned, if you do not anticipate that marriage in that new will, that marriage will revoke that will that you had before.
So you will have to create
So you will have to create a new one.
Yes.
Yes.
All right, there is one here.
No, Michelle.
Good evening, ladies. There's something called a deed of gift, and I did not hear, it was not touched on at all, really. And I'm wondering, one question is why it was not touched on,